Then let's maybe get started. So a very warm welcome again from my side. My name is Natalie Kirchhofer. I'm a life science partner here at Cohaus in Florac, a patent attorney. And for those of you who don't know us yet, Cohaus in Florac is one of the largest IP law firms here in Germany. Our main site here is in Düsseldorf. We have over 150 people working here and are specializing especially in contentious patent proceedings such as EPO opposition and nullity proceedings. This is part of part 2 of a 3-part webinar series on co-ownership and IP. Last week we had part 1 where my fellow partner Eric Schäfer laid the groundwork and introduced us to the legal concepts and legal provisions governing co-ownership. In case you missed that webinar, in a follow-up email that you will receive tomorrow to this webinar, you will also find a link to a recording of this webinar, but also of part 1 of the webinar series. And I would also like to alert you that next week we will have part 3, the concluding part of this webinar series, where Christopher Rennie-Smith, a former chairman and legal member and absolute case law expert, will give us an update on EPO case law on priority, with a special focus again on co-ownership. So we are particularly pleased to have Professor Haedicke with us, a real expert on patent law. He's a professor at the University of Freiburg. They're the chair for IP and competition law, but he's also a renowned arbitrator and former litigator and also active mediator and consultant. He acts as expert in many patent proceedings also regarding priority issues. He studied law in Munich, Geneva, and Washington. He also has a US qualification. He was an assistant professor for quite some time at the Max Planck Institute for Patent and Competition Law in Munich. And he has also served not only in private practice for some time, but also as a judge here at the appellate level of the Düsseldorf Patent Litigation Chamber. Yes, so a real well-known expert here in the German patent law space. Yes, and with that, I'm happy to turn over to you, Professor Haedicke, and your presentation.
Okay,
perfect.
Then thank you for your kind introduction. And I also want to extend a warm welcome to all of you. I'm broadcasting from Freiburg, which is at the southernmost part of Germany, the door to the Black Forest. And giving a seminar is a challenge in several ways. First of all, it's kind of awkward for me to make a seminar without seeing your faces, seeing your reactions. I kind of feel like a news reporter, but I'm afraid that this is the new normal. I have to get used to it. Secondly, I had some issues with the internet provider, but it should be stable. Let's just hope for the best. And then thirdly, I'm here at home, and many of you know the issues which are coming with this. By the way, we call it home office in German. I was told that home office in English is something completely different, which is interior ministry, but I'm not broadcasting from the ministry, but from home. So let's see if my kids keep quiet. And finally, of course, the biggest issue is that I'm dealing with rather complex issues on which we could have discussion about any detail of what I'm going to say for ages. I just try to summarize. And as Ms. Kircher has said, I'm trying to lighten it up to some degree by asking 2 polling questions, which are, of course, will be anonymous, so nobody will be traced back. So what is the basic scenario I'm talking about? We talk about, obviously, about priority rights and the transfer and the claim of priority rights. A frequent scenario is that first there was a US provisional application. From this, a PCT application came, and then the European patent application was referring through the PCT application to the US provisional, meaning that the European patent application claims the priority of the US provisional. And as you all know, a lot of pitfalls are involved with this. I will focus on the pitfalls which are happening when it comes to the European patent application. And I will basically talk about whether and under which conditions the priority right has duly been inserted. There are several issues which need to discuss. As I said before, all of them are worth a full webinar at the least. I will focus on the following issues. First of all, is if there should be any flaws in the priority, does the EPO at all have the competence to review the priority, or do they have to accept the priority if it's claimed? If so, the second issue I will touch upon is who is entitled to file a complaint? Who is entitled to say that there's no priority, has not duly been taken? And then there are several further hot issues, which I will talk about, which is what happens if there are several different kinds of flaws in the priority application. First of all, when a further applicant comes to the original applicant, so first we have ABC and then ABC and D, then the opposite scenario, I call it one applicant left behind, ABC, C falls away. This is, by the way, the CRISPR-Cas scenario where one of the inventors did not appear at the European application. So for ABC would become B. And the third scenario I will look into is the replacement of the inventor by the employer or any other forms of assignments. First question, so, is the review by the EPO. Is it acceptable that the EPO reviews the question whether a priority has been duly transferred to the original applicant? It is established case law that Article 87 of the EPC constitutes a sufficient legal basis for the assessment of the priority right. So the EPO may look into whether or not the priority right has duly been applied for. But there has been some discussion about this. For example, there is a certain tension to Article 60 of the 3 of the EPC. Let's just have a look at Article 60, which has an irrefutable presumption that the applicant shall be deemed to be the owner, to be entitled to the exercise of the right. So the issue is whether this provision should be applied in an analogous way to the priority. So that means that the EPO would be bound by the decision of the, so that the EPO would be bound by the decision of the patent applicant to file. This, however, has not been accepted because there are certain risks. First of all, we don't have a clear statutory provision for this. Then if the assessment of priority rights would be in the competence of the member states and not of the EPO, we would have the risk of torpedo claims and especially the risk of contradictory decisions by national courts, meaning that different national courts could come to different results with regard to who is the owner of the priority right. And of course, there would also be frictions between the law applicable to the invention and to the priority. So we can at least not for now say that the European Patent Organization is competent to review whether the priority has duly been claimed. Second issue I want to focus on: who is entitled to file the complaint? Who can complain about the lack of priority rights? Who has standing to sue? Who is standing to file this complaint? Is it only the person who claims to be the true owner of the priority right? This is irrelevant for third parties who is entitled to claim the priority, because the only person who has a true interest, one could argue, is the person who is entitled to claim the priority for himself. This, however, has not been the line of jurisdiction in the courts and also in the EPO. The EPO says that not only the person who files says he has the true right, has an interest to file, but the general public has an interest in formally correctly granted patent grants, and there's no clear legal rule to restrict standing to file a complaint. So also with regard to this question, we stay with the traditional opinion that everybody is entitled to file a complaint. Thirdly, there are further hot issues which are to be discussed. I already told what I want to talk about. First of all is what happens if additional applicants are in the EP application. So this is a scenario that first you have the US application with a certain set of people, A, B, and C. This can especially be the case when you have a US provisional where only natural persons were named. And then at the stage of the PCT application or at the stage of the EP application, somebody was added to the application. This can be and frequently is a company. So originally the US provisional, you had the natural people, the person, the inventors as natural as people. And then at the stage of the PCT application or the EP application, you have the company, which is the employer of ABC, who is added. There was a lot of discussion whether this leads to a undue claim of priority. And let's just look into that. The courts have said that this is that application with joint applicants or somebody is added are working. This is successful because the priority is claimed for the entire PCT application, meaning you don't divide the application. It belongs to the people who are applicants, and if somebody is added, it doesn't matter because the priority claim is not divided, it's indivisible. So it's irrelevant whether additional applicants are listed. Therefore, the adding an applicant does not harm the application. You are safe with this. One argument for this is also Article 118 EPC, which basically says that joint applicants have a uniform application. The unity of the application or a patent shall not be affected. And it's also entered into the guidelines, which say very clearly, it is sufficient if one of the applicants is the applicant or successor title of the applicant of the previous application. So if only one person is still, is identical, this is enough. So we don't have serious problems there. Now we come to a hotly debated second scenario, one applicant left behind, as I call it. What is this scenario? It's a CRISPR-Cas scenario. You remember in CRISPR-Cas case, you had the US application and you had ABC. For some reason, which doesn't matter, and for us right now, C has dropped. And so at the EP application, you only have AP claimed as owners of the priority. There have been many arguments about this, and the EPO recently, early this year, rejected the application because it said that Article 87.1 of the EPC requires filing of all prior applicants. One can bring many arguments pro and con. The main criticism which could be raised, that the purpose of the priority right is to facilitate the application in gaining international protection, whereas we here have a big serious hurdle which has been built up. However, the case is rather clear now. In January of this year, the Board of Appeals has dismissed the appeal of the patent holder, and this means that basically the game is over. There's been no referral to the enlarged Board of Appeals. So if one applicant is left behind, you have a very serious problem and your application will not be maintained. So we come now to the third scenario, which I call replacement of the inventor by the employer. and other forms of assignments. So here the parties don't claim that they are still identical, but they claim that there has been a transfer being happened. So there's a whole range of different issues which can be discussed, which I will very briefly go through. One issue is which law is applicable to the transfer? When ABC transfer to D, can this be happening? Is the transfer valid? Which law is applicable? Is there possibly an implied transfer? What is the latest moment of a transfer? And may possibly a transfer which has been effected too late maybe also yield retroactive effects. Let's just look at all these different issues. Which law is applicable to the transfer? This is a difficult discussion. By the way, I have a doctoral dissertation going on to this with regard to this issue, so you can write at least 200 pages about this. One thing is clear, that is, we don't have a clear rule in the EPC. Neither the EPC nor Paris Convention give any guidelines regarding the law applicable to the transfer of a priority right. They are just mute on that. We don't have an international private law of the European Patent Convention as such. So we need to look at other places. And you can, however, at least not directly take recourse to the EU conflict of law rules because, well, the answer is very easy. EPO is not a member of the European Union. So what shall we do now? There are different roads one could take, and I will go through all of them, which one possibility would be to take the law of the country of the subsequent application. You could also take the law of the country of the first application, or you could apply the law which is applicable to the contract. Let's just look at it. Law of the country of the subsequent application means the transfer has been effected and to a entity, for example, in the US, then US law would be applied. Is this correct? There have been some former EPO decisions that probably are no valid precedents anymore who took this road, but probably this view needs to be rejected today because subsequent applications are filed in several different countries and no harmonized law is available to that. So you have different possible applicable laws and you wouldn't have a unity of the, or legal certainty of the law. So probably this would not be a very sensible approach. Second possibility, you apply the law of the country of first application. If you have a US provisional, US law would be applied. There have been some older cases which at least to a certain degree took that view, but this is not yet settled law. You had the old BGH decision of 2013, Fahrzeugscheibe, and also one of the Federal Patent Court of 2017, Prager Berlin. Both of them at least alluded that this should be the law. And we have a rather recent decision, which however is not clear either. It's Drahtloses Kommunikationssystem of 2018, in which the court stated that at least for the contractual applicable law to the contract, not for the in-rem contract, the original law would have to be applicable. I don't think this is, well, we don't have clear precedents for this, and probably this is not the best solution because you do not have a close connection between the country of first application and the transfer. If you have a European patent, why would you use a US law, or just because the priority right has originally been clear, the first priority has been coming into existence in the US. And priority rights are, as we all know, independent from first application. So there's not enough of a nexus between the country of first application and the priority right. This means we come to the third possible way, the applicability of the lex contractus, meaning of the law of the agreement. This, in my view, would provide legal certainty. And it is, we said before, we don't apply the law of the European Union, but if you look into the IP laws of all EPO member states, you nearly always come to the same result, that this law is applicable under the respective IP laws of the EPO member states. The reason is that they all cling to Article 4 of the Rome I regulation 593 of 2008. What does it mean, lex contractus? First of all, the parties may choose the applicable law. So if they have a choice, if there's a choice of law clause in the transfer agreement, then this law governs. And then secondly, if there's no choice of law, then the law is applicable of the country where the party is required to effect the characteristic performance of the contract, meaning the country of the residence of the assignor. And this probably gives a rather clear guidance. And I could imagine that this will eventually be the law as soon as the law has been settled. But of course, we have to wait and see. Also, this is not settled. We are in a rather unclear area here. So second issue is, what are the preconditions to really have a full-fledged transfer? Of course, if you have an agreement which is clear, which states that the property has been transferred, there is no issue, you don't need a lawyer then. But many times, and we have very prominent cases for this, look at the Humira case, look at the CRISPR-Cas case, the transfer has not been, at least not completely clear. So it can happen that the inventor is replaced by the employer, that you need a transfer, or there can be a transfer in a group of companies. And also in all of these cases, the question is, what requirements do you have for a full-fledged, for valid transfer? Let's just look at, for example, what implied agreement is. So you can at least argue, and you need to argue because it's not clear cut, but you can argue that under certain conditions, the employer has obtained the priority right from his employee under the German Employees Invention Act if it has been, if there have been communications to that end. The good thing is that if you apply German law, German contract law is rather flexible in this regard. The German contract law, maybe in difference to Anglo-Saxon laws, does less cling to the wording of the agreement and looks very, very much to the true intentions of the parties. So we have a very flexible rule of contract interpretation. We have different kinds of interpretation, subjective interpretation, meaning that you look at what the parties really wanted. So if both parties, for example, in a group of companies, were clear that with the communication between different parts of the group, the priority was to be transferred, and both parties wanted this, you would probably have a transfer, a dual transfer priority, even if it has not been reduced to writing. So subjective interpretation plays a rather important role. You look at not only at the wording of what the parties said, but what an objective third party would understand, what the intention of the parties are. This is objective interpretation, meaning, again, you don't take the wording too literally. And even if there are gaps in the agreement, sometimes supplementary interpretation can help. I don't say this helps all the time, but at least there is space to argue, because German contract law attaches great significance to the good intentions of the parties and to good faith. And another open question is whether the transfer of equitable title could suffice under, I don't talk about UK law now, but German law. This again is undecided. And the question is whether it is sufficient to transfer the right to claim the priority. This, for example, can be the case if you have a US provisional and the holder of the later full US application has a equitable title. And if this is transferred, it could be argued that the transfer of this title would be enough. The requirement, however, would probably be that the priority itself must be transferred later. As I said, this is undecided in Germany, but it gives, again, room for a lot of interpretation. Another issue which one can think about, until now, it is clear that the subsequent application must have been filed within the 1 year, and the priority of the subsequent applicant must be with the subsequent applicant by that time. This means you just have the maximum 1 year time between the first application, the priority application, and the subsequent application to transfer the priority right. There have been such suggestions, but again, I don't talk about black letter law, but about possible ways to change the law or to argue that you do not necessarily have to transfer the priority within the 1 year period between first and subsequent application, but maybe it could even be enough to transfer the priority right until the end of the examination proceedings, because only then all requirements for the grant of a patent must be fulfilled. The question is whether there's any interest for third parties, for the general public, not only that the priority has been claimed, but that the claimed priority is vested with the applicant. Maybe there's only interest that this priority is vested with the applicant at the very moment this examination procedure is terminated, because then all requirements for the patent need to be there and need to be vested in the applicant. But you see my question mark, I would certainly not say this is settled law. A final possibility to heal transfers of priority which have not duly worked. But this again has a big question mark. May there possibly be a retroactive effect of the transfer? This has been rejected by the EPO, so you have to be very careful. But at least in the German law, at least one can ask the question whether the transfer which can be valid retroactively could, under section 184, 185 of the German Civil Code, could also have effects to the transfer priority rights, meaning that possibly, but this is probably the weakest road which I could, if I need to decide that maybe a retroactive effect could be accepted, but of course I doubt it. So if we look into the whole picture, which I was trying to give you in a rather short time, we come to different results, which I painted either in green, red, or yellow. Green means competence of the EPO to review priority is clear. Who is entitled to claim the priority? Only the patent, not only the patent, the person who has a vested interest with everybody. And then additional applicants, joint applicants work, so the priority can duly be claimed. One applicant left behind, the transfer does not work. And the replacement by the inventor, by the employer, and other forms of assignment are, well, they are yellow, meaning the transfer may work, the transfer may not work. It depends on the individual circumstances of the case. So to sum up, we have green, yellow, and red. So the additional applicant transfer works. One applicant that left behind does not work. Replacement of the inventor by the employer, other forms of assignment may work or may not. If we look at the balance, and here I have a short survey for you. If you look at the balance, the question is whether the EPO practice is too strict and whether it should be changed. So I was implementing a short survey. Does the current EPO practice provide a fair balancing of the interests? What do you think about the strict approach of the EPO relating to the transfer of priority rights in the CRISPR-Cas case or similar cases? So you have the option to choose either the approach is too formalistic, the approach is correct, or it should only matter whether the priority is at the right place when the patent is granted, because it's all that matters. This would be the third theory, saying at the latest moment in which the priority needs to be with the applicant is the moment of the termination of the proceedings. As I said, this is anonymous, so would be happy to see your, to see the results, the survey results soon, and everybody is cordially invited to take part.
Yeah, I see 40% have not yet answered, but the number is rising and rising. I think we can close the survey in a couple of seconds. It should already be representative with 70% having answered. So I think I will close the survey now.
So you can see the survey results now. It's interesting, we have about 50%, half of the auditors of the audience says that the approach is too formalistic, and they criticize the EPO in the CRISPR-Cas case. It should be enough. It's one person of the priority application and subsequent application is identical. And all 23%, 1/4 says the approach is correct. And oh, I like the third, answer, which is a theory which I am very fond of. They say it should only matter whether the priority is in the right place and the patent is granted, because this is all that matters. It's interesting. You see that the discussion is going on, and of course we know that when the EPO has decided the CRISPR case, the game is probably over, but who knows that at least in the other cases, a more flexible approach may eventually come to life. Okay, I would stop this, and I would just like to go back to one other question, which for some reason didn't show up. It was about to be in the very first start. For some reason, it was my introduction. Okay, this is it. So let's just have a look to these lines. You see, you see an iceberg, and I say there are several cases in which the issue of the priority right has been decided. You have some EPO decisions, you have the CRISPR-Cas case, you have some German cases. My question for you would also be, is this just the tip of the iceberg? And my question would be whether you in your practice ever have to do with issues relating to the transfer of priorities. Is it just an academic topic which has come to life just because of CRISPR case? Or do you think this is something which is important in daily practice? As far as I know, many of you have to do with this. This is a rather hot issue, and some people even say this is in fashion right now. Like legal concepts, sometimes they come up and they go down again, but right now this is very hot. Let's see how the real world works and if you have ever to do with these issues.
And so I think, again, over 75% participation right now. So I will close the poll and share the results with you.
75%, 3/4 have to do with these issues. So my idea, my suggestion that we just, in these cases, only just see the tip of the iceberg seems to be correct. Okay, then I think we can close this. And of course, we go through it very quickly now. And I hope that even though I only could touch some of these issues very briefly, I hope that it helped you, and I hope that I was able to give you at least a short overview of the relevant issues and about the ways in which one can argue and possibly develop the law even further. And for this, I very much thank you for your kind attention, and I'm glad to see that so many of you took part, and which is even better, none of you dropped between the during the presentation, which I think is great. And thank you again for listening to me.